Okay. All right. So I think we've all been doing Zoom long enough to know the drill about how this works, but I do need to advise you that this is being recorded, and it will be available on the Bar Association website. I'm sorry, Zoom site, excuse me. No, YouTube site. Well, nothing like stumbling over yourself at the beginning. But my name is Ann Dalton, and I am the co-chair of the ADR practice section. I am absolutely thrilled that we were able to acquire the services of Henry Paul this afternoon in an ethical presentation. Henry has a long and storied career in the field of ethics, and of course, as you probably all know, he's a former Florida Bar prosecutor and has left that job and now represents people who have ethical issues or have claims of some sort that are brought by the Florida Bar. Over the years I've known Henry, he's been just an incredible resource of information, and I'm trying to make him blush, and it's not successful, so I need to stop talking at this point. But I do need to advise you that this presentation will be available on the Bar Association YouTube site. I got that one right finally. Henry has also prepared a comprehensive outline of the cases that he will be discussing today. Lauren is going to be sending that out with the CLE certificates because Henry is the most organized person in the universe. He actually prepared this long enough ago that we actually have CLE certificates available today. So with that introduction, I'm going to turn it over to Henry. Thank you, Henry.
Well, Ann, thank you for that very kind introduction. And it's a pleasure to see those out there, even if it's only virtually. See some friends in the audience there. I am speaking to you virtually from my home in Tampa. And that fits right in with the topic, ethical considerations in virtual practice. And I apologize, my voice is a bit weak. I've been suffering with a lung infection for several weeks and took my cough syrup and hope I can get through this. And I excuse myself in advance if I do have some coughing. Ann spoke with me in the spring, back in April, about possibly doing a CLE on this topic. And in March of this year, really the subject of this topic was created by the ABA in their formal opinion 498, which is entitled Virtual Practice. And I told Ann, and when talking about it, that I'm not a techie, I cannot give technical advice, but that I had done a 2013 webinar for Reptile on ethical issues in the computer age. And I had also already written my Res Geste article on ABA 498 by the time I spoke with Ann. That came out in May. So I felt that despite my technical deficiencies, I could get into the ethical issues that have been raised in the 498 opinion and others. And I'm going to basically go over the ethical concerns without getting into detail about technical issues, except as raised in these authorities. And one good piece of advice is get a good consultant or someone who knows what they're doing when issues come up. But in going back and preparing the outline back in April and preparing for today, and I looked at my 2013 PowerPoint, and I realized just how much things have advanced in 8 years now. And they've changed so much that, you know, the opinions I was citing back then were saying, addressing things, well, it is ethical to communicate by the internet. Well, that's really ancient history. And that is recognized in ABA 498, which dealing with virtual practice, it is now a reality. And as this was defined, virtual practice was defined by the opinion as technology-enabled law practice beyond the traditional brick and mortar law firm. And I call it technology-enabled, pandemic advanced or fueled. And I'd just like to talk a little bit about how much things have changed. Of course, the pandemic has really advanced things. And one of the ways to look at that, other than just our anecdotal experience, is there are 3 Florida bar surveys that have been taken recently. And you can find them on the Florida Bar website. There was a member survey and results announced in February of this year, a pandemic recovery survey in June of last year, a video conferencing survey, I think if I can read my writing here, October of last year. And all these are very lengthy and detailed, and give a great insight into the way members of the bar are thinking and dealing with the changes in the law practice that we're all confronted with. So those are good resources to look at. But one thing is clear, there is not really a desire to go back to the practice of law the way it was before. And virtual practice, Zoom, WebEx, Teams are here to stay, and many other platforms that I'm sure others are using now and that will be introduced in the future. Another item that indicates let me just look at my authorities here, that indicates a change in the practice of law is the loosening in restrictions against UPL. And there was another ABA opinion sort of related to these issues of remote practice. And this one was called remote practice. And I believe that was in 2018, ABA 495, remote practice. And that basically laid out the guidelines for authorizing a lawyer in one state or one jurisdiction to live in a separate jurisdiction and still practice in the home jurisdiction. And previously that was not allowed, but the ABA led the way and said under certain conditions, with having all your contact information in the home state, no indication of contact in the state that the lawyer was living in, not the home practice state, but the out-of-state jurisdiction of residence. And of course, not representing lawyers in the out-of-state place of residence, that it was possible to do that. And that seems like in our day and age, it's something that would just be recognized as appropriate in the way our society is developed. But it took some time and practice, and the Florida Bar finally did follow up with an advisory opinion from a lawyer in New Jersey. I don't think I have this case number in the outline. It's administrative order AOSC 21 dash, oh, I'm sorry, excuse me, Supreme Court case number 20-1220, approved the advisory opinion recommended by the bar and authorized a lawyer from New Jersey to live in Florida and practice his law in New Jersey remotely. So that seems like, we look back at that in 8 years, and it's going to be hard to believe that that was even an issue, but it was. And, it made some waves around the country, but it's really in light of where we are in the society. I can't see the court coming down any other way on it. And kudos to the American Bar Association for giving some guidance on that helped the Florida Bar feel comfortable with that position. So I will get into the the opinion that is really the basis of this entire presentation, ABA 498. And make sure I've got the right, here it is. And it takes the sort of the approach looking at ethics, 3 ethical concerns that are all interrelated. And I'll just read the summary of 498. And as I said, it identifies the 3 main ethical issues. And it says that when practicing virtually, lawyers must particularly consider ethical duties regarding 1, competence, diligence, and communication, which it clumps together, especially when using technology. In compliance with the duty of confidentiality, which is the second identified ethical issue, lawyers must make reasonable efforts to prevent inadvertent or unauthorized disclosures of information to the representation and take reasonable precautions when transmitting information. Additionally, the duty of supervision, which is the third main ethical issue identified in this opinion, that it requires that lawyers make reasonable efforts to ensure compliance by subordinate lawyers and non-lawyer assistants with the rules of professional conduct, specifically regarding virtual practice and policies. And so really all the authorities that I get into basically go back to this same sort of analysis. And you keep hearing the same or similar language and the same ethical concerns repeated and elaborated on. So it was probably, about 8 years ago. I know when I did the 2013 seminar, it was relatively new. The ABA model rules led the way in making competence include technological competence. And the Florida Bar followed suit again and added the comment to Rule 4-1.1 competence, probably about 8 or 9 years ago. And the comment says that a lawyer is required to maintain the requisite knowledge and skill. A lawyer should keep abreast of changes in the law and its practice, engage in continuing study and education, including an understanding of the benefits and risks associated with the use of technology, and comply with all continuing legal education requirements to which the lawyer is subject. And what is a corollary to that is a few years ago, the Florida Bar, approved by the Supreme Court, included a 3-hour CLE requirement on technology. And a lot of jurisdictions have followed suit around the country. And the opinion went on to say that lawyers should have plans in place to ensure responsibilities regarding competence, diligence, and communication are being fulfilled when practicing virtually. And without these 3 tandem obligations, the obligation to comply with duties of confidentiality and supervision cannot be met. So they're all dovetailed. So with that basic introduction discussed, I'll go into the obligation of confidentiality. And what I've started with is, I will get into more details at the end of my presentation from the ABA opinion, but I thought I would start off with reviewing some Florida resources that are helpful. And these supplement the ABA provisions. I tell you, it's good for anybody with questions about technology to review these resources, and especially this ABA 498. And there's another one that I'll get into, 477R. that have really focused in and tried to drill down on technology issues. And the difficulty that they have is it's moving so quick. The Florida bar just has a hard time keeping pace. So far, it seems like the ABA and the commentaries have been a quicker to provide some guidance. And one resource that I will recommend is the Sedona Conference has produced all sorts of authorities and assistance on technology and how to deal with it. And I know it's often cited by courts. And my last federal court case, the judge specifically suggested that we look at their guidance and try to be compliant with it. So the first opinion I'm going to refer to is EO Ethics Opinion 6-1 in the year 2006. And this deals with electronic files. And surprise, it says, well, there was some question as to whether files may be stored electronically. Well, we've come a long way since 2006. Well, of course they can, but reasonable precautions have to be maintained. And the opinion basically talks about what reasonable precautions are. And they pointed out that original documents, such as wills or other deeds, perhaps, or other original documents still have to be maintained, but other files can be maintained electronically. And as long as they're readily reproducible and protected from inadvertent modification, degradation, or destruction. And there's some special concerns that should be dealt with. And they say they're talking about not only the original documents, but documents that need to be kept for 6 years, such as executed contingent fee agreements, statement of insured clients' rights, advertisements need to be kept for 3 years, and trust accounting records need to be kept for 6 years. Other than that, there's not a real bright line rule on how long a lawyer has to keep files. And my suggestion is that these issues are ripe to be dealt with in the fee agreement and discuss them with the client. For example, my fee agreement says I'm free to destroy my files other than original documents, which I would return anyhow, what few ones I might have upon the end of the representation, but that I'm free without further communication to destroy those files. And any other type of particular issue regarding maintenance of electronic files, just get it out in the fee agreement, and it's a great protection for you in case something happens down the road. And I can tell you one thing, I wish that I was thinking of Jerry Chapala. I was his inventory attorney, and a lesson was learned from that. I don't think he ever destroyed a file from when he started practicing in the 70s. And we had to go through all those files. His file destruction policy was no destruction. God bless Jerry, I loved him, but I spent 1.5 years going through those files with bug infested. And I wish he had not only put them electronically or destroyed them, but had communicated with his clients. So in today's age, there's no reason not to repeat ancient history. And it's easy now with the advantages we have and the technology we have to make this an easier process, to get agreement and not have an issue with the bar when files are destroyed. One just caution that I will make is that, malpractice is 2 years from, the statute of limitations is 2 years from when the cause of action arises. And that cause of action sometimes can take a while when the harm is done. So that's one consideration. Some people may think it's better to keep the files longer than 3 years, 4 years, 5 years, whatever they feel appropriate in the particular area of practice. In my area of practice, I don't feel it's a great issue, but practically speaking, I keep my files electronically anyhow. I don't have a problem with that. I don't have the volume of files that I need to destroy them. Okay, the next opinion is on metadata. It's opinion 6.2, the next opinion from the one I just talked about. And it defines metadata as information about information which has been defined as information describing the history, tracking, or management of an electronic document. This goes through what metadata is, but more importantly, and also just as an aside, it cites the Sedona guidelines as a valuable resource. And I'll talk about the duty to return inadvertent disclosure in a little bit when I talk about the rules related to that in Rule 4-4.4. But this opinion states that there's some obligations. Number one, it is the sending lawyer's obligation to take reasonable steps to safeguard the confidentiality of all communication sent by electronic means to other lawyers and third parties, and to protect from other lawyers and third parties all confidential information, including information contained in metadata that may be included in such electronic communications. And I can't give examples of exactly how that can help. I know it can help people in discovery issues when things are not produced in native form. And I know there have been issues about metadata, but for example, I think just a basic thing, to the extent you can protect it, just converting a Word file to PDF is one way to do it. And I know there are a lot more ways to do it, a lot more sophisticated. Now, number two, just as importantly, in Florida, the recipient lawyer's concomitant obligation upon receiving an electronic communication or document from another lawyer is not to try to obtain from metadata information relating to the representation of the sender's client that the recipient knows or should know is not intended for the recipient. Any such metadata is to be considered by the receiving lawyer as confidential information which the sending lawyer did not intend to transmit. That's a presumption there. That's important to realize. And I've seen lawyers in the state of Florida, which has a strong protection here of not fulfilling their obligation to inform a sending lawyer of a mistake that has been made in sending material that was not intended to be disclosed. The next ethics opinion is 10.2, and this is storage devices, is what I refer to it. And many people may not realize, I think more do now than when this opinion came out, that storage media such as printers, copiers, scanners, facsimile machines, and other items scan the material and keep it on their file, on their hard drive, and those can be recovered. So just as a lawyer should not be throwing client files out in a dumpster open for somebody to retrieve, the same goes for, you have a printer on a lease and it goes back. Well, there's you should have an obligation to make sure that that is scanned or somehow destroyed. And when you have make a contract with someone who might lease a machine, that is one item that should be addressed. Another item of interest is and I'll read from the opinion, a lawyer should use care when using devices in public places, such as at copy centers, hotel business centers, outside offices where the lawyer and those under a lawyer's supervision have little or no control. This includes Kinko's. It's a hard workaround sometimes. In such situations, the lawyer should inquire and determine whether the use of such devices would preserve confidentiality under these rules. I guarantee you most of them don't. So that's just a consideration to keep in mind. How do you work around it? I'm not really sure at all times. Ask a consultant. And that's my answer for a lot of questions here. The next one I would like to address is EO 1213, and I call this the cloud, and the obligation that a lawyer using the cloud, and back then not as many were using it, but everyone almost uses the cloud now in some form or another to store material, to back up material, in addition to an external hard drive. And the use of cloud computing raises ethics concerns of confidentiality, competence, and proper supervision of non-lawyers. And one piece of advice I can give you is do not use a company with servers in Russia or China. Not a good idea. You need to investigate a little bit, read some reviews, read your agreement with the storage facility. Make sure they're reputable, and the opinion suggests try to ensure the online data storage provider has an enforceable obligation to preserve confidentiality and security, and that the provider will notify the lawyer if served with process requiring the production of client information. I can tell you if you have a server storing information in Russia and they have to produce documentation, I doubt you're going to get served notice or an opportunity to protect it. Second, investigating the online data storage provider security measures, policies, recoverability methods, and other procedures to determine if they are adequate under the circumstances. And third, employing available technology to guard against reasonably foreseeable attempts to infiltrate the data that is stored. Now, I'd like to move on to the next ABA opinion that is cited and relied on by 498, and this is 477R, and it's called Secure Electronic Communications. And this really, it's a pretty in-depth opinion, and it talks about the confidentiality rule 4-1.6 E, and it talks about the obligation that a lawyer must make reasonable efforts to prevent the inadvertent or authorized disclosure of or unauthorized access to information relating to representation of a client. What this rule is, and the comment to the rule is, it really provides a safe harbor to lawyers. As long as the lawyers involved meet reasonably appropriate standards, they are not going to be held liable for a violation of the rules. And this happens a lot when there's an incursion. Ransomware attack, hackers, getting in, obtaining information. The analysis that the bar would look at is, were reasonable precautions taken? And it's sort of a continuum about the amount of information, the sensitivity of the information, what is reasonable in light of those factors in storing the information. And you really need to be aware that there is this obligation. You want to make sure if there's a problem, you've met the safe harbor protections. And the comment says, it's fairly lengthy, but I think it's worth reading, that paragraph E, which I just read, requires a lawyer to act competently to safeguard information relating to the representation of a client against unauthorized access by third parties and against inadvertent or unauthorized disclosure by the lawyer or other persons who are participating in the representation of the client or who are subject to the lawyer's supervision. The unauthorized access to inadvertent or unauthorized disclosure of information relating to the representation of a client does not constitute a violation of paragraph E if the lawyer made reasonable efforts to prevent access or disclosure. Factors to be considered in determining the reasonableness of the lawyer's efforts include, but are not limited to, the sensitivity of the information, the likelihood of disclosure if additional safeguards are not employed, the cost of employing additional safeguards, the difficulty of implementing the safeguards, and the extent to which safeguards adversely affect the lawyer's ability to represent clients, e.g. by making the device or important piece of software excessively difficult to use. A client may require the lawyer to implement special security measures, and that certainly happens in tobacco cases, for example, to use. A client may require a lawyer implement special security measures not required by this rule, or may give informed consent to forego security measures that would otherwise be required by this rule. So what 477 talks about, what constitutes safe harbor, what is a reasonable effort. Again, it talks about the general factors, sensitivity of the information, likelihood of disclosure if additional safeguards. This really mirrors what's in the ethics opinion. And they give a list of topics, and they have discussion. I won't go into all of that. I'll just read the headers. You should understand the nature of the threat. 2, understand how client confidential information is transmitted and where it is stored. And that means knowing who has access to it. You have employees who have their own devices who may have access to it or download information. This especially happens in outsourcing, which is an increasing issue in today's world. And I'll go into, there's an outsourcing opinion, which I will discuss in a little bit. You have to know who has it and where it is. Understand and use reasonable electronic security measures. Again, get a consultant, unless you're a PJ Shiner. 4, determine how electronic communications about clients matters should be protected. Do you use encryption? Do you use a portal? Do you use just plain email? And one issue I see is, clients like to communicate easily sometimes and may not realize if they're being emailed at work, their employer has access to those emails. That's certainly something that should be discussed. Label client confidential information. Well, this is can be a very important item as to privilege. In order to protect privilege, it's important to identify it as a privileged communication and only send it to parties to who the privilege is applicable. Many years ago, I was in 5 years worth of litigation involving privilege in some very large healthcare provider. And one of the issues is things that they were claiming privilege that were very incriminating got sent out to all sorts of people other than those who really had the need to know and were covered by the privilege. case finally settled before that got resolved, but we litigated that issue for 5 years. It can become a very important issue. Train lawyers and non-lawyer assistants in technology information. And I just give you an example I had. I represented a car dealer one time in a Lanham Act and advertising case, and the opposing dealer requested all the information regarding their work, and that included all the salesmen's and employees' information they had downloaded or they had or communicated with customers on their personal cell phones. I can tell you, those salesmen were freaked out when they got a request to preserve. We never had to produce it. That case settled, but I think it led to the settlement because it was disruptive and it was intrusive. And no one had suggested, you need a firewall between your personal information and your other information. Now, there are ways to do it with experts who can look at it, but it can certainly cause some consternation. Conduct due diligence on vendors, and they suggest factors involve reference checks and vendor credentials, vendor security policies and procedures, hiring practice. Vendor can have people who are not, that don't have the best background, and they can purloin information. Use of confidentiality agreements, and that can be done with employees or third-party vendors. Vendors' conflict checks to screen for adversity. Availability and access of legal forum for legal relief of violations. What does a vendor do, or what do you do if there's a problem? Try and go up against Google, and you realize that can be a substantial issue. Okay, the next opinion I'd like to discuss, I call it When Disaster Strikes, Formal Opinion 483. And I know most unfortunately, there are some here with unfortunate experience. What do you do? What is a lawyer's obligation after an electronic data breach or cyber attack occur? And I'll read the summary of this ABA opinion 483. Model Rule 1.4, which is equivalent to our 414 communication, requires lawyers to keep clients reasonably informed about the status of a matter and to explain matter to the extent reasonably necessary to permit a client to make an informed decision regarding representation. The rules address the risk that accompany the benefits of the use of technology by lawyers. When a data breach occurs involving or having substantial likelihood of involving material client information, lawyers have a duty to notify clients of the breach and to take other reasonable steps consistent with their obligations under these rules. Data breaches and cyber threats involving or targeting lawyers and law firms are a major professional responsibility and liability threat facing the legal profession. As custodians of highly sensitive information, law firms are a target for hackers. No matter how much is done, and if anybody wishes to chime in here, please do with any unfortunate experience, please feel free to. But this is such a scary concern, and it happens, and all you can do is do your best. You have to inform the clients. And I tell you a scary thing about informing clients also that you may not realize. There is a New York formal opinion from the New York Committee of Professional Ethics It's in the outline 2017-5. I did write a res geste article about it. U.S. border searches of electronic devices. You go across the border and coming back in, you're subject to border searches. You can be subject to foreign searches when you leave. And if you have access, if you have your phone or your tablet or your computer, they have the right for warrantless searches. That was recently held in a 2021 First Circuit case. And it's pretty widely recognized. In 2017, there were over 5,000 warrantless border searches of electronic devices in February, 5,000 in February, and over 50,000 in that year. So that's a concern when you go overseas and the holidays are coming. Getting back to 483, and what do? Again, get someone good to help you. You know, really the least of you, I won't say it's the least of your concern, but you just want to do what's reasonable. You got to get someone good to help you. You have to go the extra mile. Hope you have done your best to keep whatever information you can. Hope you have tolerant clients, and hope you can survive. And this is a lengthy, it's a 16-page opinion. If you're making a plan or thinking about concerns, or if you have been the victim of a cyber attack, that is a very good resource to review. Just one thing I'd like to consider, portal communication. I use Clio. That's fairly secure. There are many other portal communications where they log in to a secure website. I would certainly consider that with your clients, but a lot of times it's just not practical. And a lot of times clients just simply do not want to go through the hassle of doing that. But it's certainly worth disclosing and discussing forms of communication with your client. And again, it provides a safe harbor to you if you've had that discussion with the client. Briefly, inadvertent disclosure. Florida Rule 1.285 and Federal Rule 26B5B have an obligation, require the sender or gives them the ability to challenge. But Florida Rule 4-4.4B puts the obligation on the receiver to notify the sender of receipt of information that is obviously mistakenly sent. It's a far greater obligation. And I have seen people have some problems for not doing that. And it can cause all sorts of problems, not only for the lawyer, but for the lawyer's client, as motions, to disqualify or motions to impose sanctions because this information has gotten out, been used, been given to a client, and the bell can't be unrung on that. The third ethical issue raised in 498 is the issue of supervision. And I will go through this if I have a little bit of time to go through and identify in 498 some further discussion. But I would like to point out ethics opinion in Florida 7-2, which is, I call the outsourcing opinion. And it basically says outsourcing, and this was dealing overseas, but outsourcing overseas or within the country, the same issues apply. A lawyer is not prohibited from engaging the services of an overseas provider to provide paralegal assistance as long as the lawyer adequately addresses ethical obligations relating to assisting the unlicensed practice of law, supervision of non-lawyers, conflicts of interest, confidentiality, and billing. The opinion goes on, a particular concern is the ethical obligation of confidentiality. The inquirer in this case, we're going to be using foreign attorneys, and they wanted them to have remote access to their computer files to be able to work on the file, supposedly under review or supervision of the host attorney. And the bar in this opinion says you can have it, but you have to have a firewall. It's only limited to that particular client or particular information. And you always have to be mindful. You have to be mindful of other vendors, part-time or otherwise, what they have access to. And with technology today, you can do quite a bit to secure that information. And another issue raised in this and an old ABA opinion, which is still cited, and that's in my outline, 93-379. When you're outsourcing, the bar takes the position, you can't, if it's not a full-time employee, you can't hire a paralegal who's not a full-time employee, who charges you $50 an hour and then bill that part-time employee out at $150 an hour. You can't add a surcharge on that, and you can't do it for other things. And this opinion, and especially the ABA opinion, extensively discuss that. Now, I see time is getting close. I will just briefly go back further discussion of specifics in opinion 498. If I can find it here.
What do you want? No.
Of course, I put it at the bottom of the pile. I'll just go through as briefly as I can. The opinion goes into particular virtual technologies and considerations, talks about what you should do and what you should look at and consider dealing with hard drive and software. And it makes a particular note of looking at the agreements and take particular notice to data soaking information software that track and collect data. One thing to be careful of, lawyer websites. Sometimes vendors put clauses in there that they own it, and the lawyer can be out of luck if they move. Talks about using strong passwords, antivirus, encryption, security-related updates. Second is accessing client files and data. We discussed a lot of these three virtual meeting platforms and video conferencing. Well, we're all experiencing that. And I know everyone's probably got stories, but professionalism still applies, even if you're working out of your home. And virtual document and data exchange platforms, smart speakers, virtual assistants, and others. Alexa, Siri, and others, be careful. They're recording things and they can get hacked. And they recommend don't use them in the practice of law unless they have a specific purpose or you can protect them. But I've heard horror stories of things inadvertently getting recorded. Supervision, and it goes into supervision of subordinates and associates and vendors. And it talks about the limitations. One thing it advises in this day of technology, you got to remember to check your mail. You still get items in the mail. And I can tell you one thing that I deal with, people haven't gone into their office for weeks and they got a old time bar complaint by snail mail. And they go, gee, I never got it. well, you still have the obligation to check your mail. And with that concern, with the Florida Bar in mind, I'm through. I think time's up. So,
I'm sorry. I just want to add one thing to your presentation. I had the unlucky event of dumping a full can of soda into my computer. I don't recommend that, even though many people say their lives are pretty boring right now. I don't know that that's an exciting way to jazz up your life. But based upon that, I said, well, no problem. We can go out and get the stuff off the server, off-site server, which of course we hadn't checked in months because we had no reason to. They were out of business. We had prepaid for a yearly fee and of course had no reason to check. And so the only thing I can add to your most excellent presentation is once in a while, be sure to check and make sure that they're still in business and you still have your stuff being stored off-site.
well, I'm sure everyone has a story out there, hopefully not as painful as that one, but I know there are a lot more painful ones, unfortunately, that have been experienced in our local community.
Thank you. Well, I don't see any more inquiries, so I'm going to thank you at this point, Henry. You did your usual fabulous job, and I will tell everyone that Henry is very much under the weather. So this is a heroic effort on his part that I hope we all are most appreciative of. I'm going to put a plug in for our next session with the ADR practice section. It's October 13th at noon. And what we're talking about is the expansion of the non-binding arbitration process into other arenas. The specific discussion will be the family court. I know there's a lot of people who are on this call and who belong to the section who are not family court mediators, arbitrators, or practitioners. But I would urge everyone to attend because really the focus of it is it time to expand non-binding arbitration into non-traditional venues? Should be a pretty exciting conversation. And I know there's at least one judge who's planning on attending, and I'm hoping to get a couple more to attend. So, but thank you, Henry. Really, most excellent as always. We are so lucky to have you as a resource.
Well, it's always a pleasure, and I really enjoyed seeing everybody's little picture up there.
Thank you, Henry. I
Thank you.
appreciate it.
Okay. Have a good day, everybody.
Have a great day.
Okay.